Parties commencing litigation will be considering many things. They may be thinking about their evidence or their legal arguments and how to get the best outcome in the litigation. But they should also be thinking about the array of risks which will arise in the course of the litigation. In this video, we'll be considering those risks and how they can be assessed and managed.
So firstly, I think it's important to think about who are the key decision makers within the business dealing with the litigation, and remembering that they are humans and therefore they will have their own interests and motivations, and understanding that litigation and litigating well is a time-intensive, dedicated exercise and can be, stressful and psychologically challenging. So you have to take those factors into consideration in understanding the risks and how they might impact on those people concerned.
We're increasingly using technology to help us identify risks and potentially mitigate them in the course of litigation with our clients. Now, an obvious example is at the outset, we have a document management platform where we load on all the data, and it gives you an idea, frankly, of how much data you might have to grapple with during the course of a case. You might not want to interrogate it all at the outset, but quite often complex data analytics tools will allow you to do some visualizations without even having to delve into the detail on who might be appropriate to talk to, who's communicating with whom and at what time, what documents might you need to search for, what keywords might be relevant. Ideally, you'd find that smoking gun document very early on in the process so that you can identify that risk with your client, discuss how best to adapt your case strategy to account for that smoking gun document, rather than finding out about it much later down the line, perhaps in the disclosure process, or even worse, when the witnesses are in the witness box at trial. Ultimately, when it comes to legal technology, the quality of the input is key. The better the input you put in, the better the output that you'll get. And certainly as we move forward and the forthcoming AI revolution, that can only get better and will help us advise our clients better in terms of the risks associated with their case.
One factor that can significantly complicate litigation can be the psychological factor. By the time people even contemplate litigation, emotions can be very high, and that is only exacerbated during the course of litigation generally. Studies have shown that when you have sort of intense negative feelings, it impacts quite significantly on your ability to take decisions, and particularly where people are angry or feel very aggrieved, that can impact on their ability to take rational choices, really balancing the cost-benefit analysis that we would hope would run throughout litigation to make sure that you were achieving your objective. As a litigator, we try to address the psychological factors that can impact on decision-making in litigation by taking a step back and ensuring that from the outset, with the client, we work to identify what their overriding objectives are in the litigation. Remember, in litigation, it's very rare that actually what you want is a victory before the court. What you want is success in terms of an outcome to the litigation that you are satisfied with, and actually rarely is that to do with the judgment. It may much more be to do with the terms of a settlement that can be reached with the other party. So taking that step back, looking at what the overriding objectives are and designing a strategy around that. And our role is to try and feed in all of the different risk aspects to make sure that there can be rational decision making rather than emotive decision making. And that might include acting as a sounding board for practical ideas that the client will look into for the purposes of resolving the dispute.
Harshif Thakrar is Chief Investment Officer for Assertes, a business specialising in litigation funding.
The assessment of risk in litigation is everything that we do day to day. When we're investing in a claim by way of funding or purchasing, we assess the risk in an overall prospect of winning the claim. We're assessing whether we think that there will be a successful monetary or asset outcome at the end of the claim sufficient to discharge the amounts owed to the funder, the amounts owed to any other participant in the claim, including the law firm, counsel and insurer. We're also ensuring that the claimant sees a sufficient amount of their award at the end of the claim that they are happy to participate in the funding amount. The assessment of risk feeds into all of those factors and whether we think that we can invest in the claim for the benefit of the claimant and of course for the benefit of the funder and all the other participants. We'll of course look at enforcement risk. We'll look at the commercial factors, for example the propensity of the other side to settle, the commercial dynamic between the two claimants, if there are businesses that are now at loggerheads or they might well be looking to do work together in the future, or whether we think the other side will just simply dig their heels in and never capitulate. So we'll look at the overall settlement risk. We'll look at the economics of the claim. For example, our client's propensity to settle. We'll look at the investment size to the overall quantum and what we think the key components of quantum might be. We'll also look at generally the enforcement risk of the other side and whether we think that the directors and the protagonists on the other side of the dispute are likely to fight this all the way because they believe that it's existential to the business of their of their day-to-day, or they think that it's something that they can close off in a box and continue their business successfully otherwise. So there are a number of different points that we assess overall to assess what the overall risk in the picture might be, and we generally try to come out with a view as to whether to invest or not. Overall, we will assess reputational risk, not just to the claimant, but to us as a funder. For example, if we are purchasing the claim and we become the named claimant, there may be a reputational risk. We will assess whether we are on the side of right or wrong. We always want to be on the side of right and not just apply black letter law to claims which may have merit. We also want to assess what the management time and opportunity cost of litigation might be. As we all know, litigation can be very time consuming, can be very emotionally taxing, and us as a professional litigation funder and purchaser can take away a large amount of that burden. The other risks can involve adverse costs, for example, or other pieces of evidence coming out at trial that might feed into the overall risk of taking on a piece of litigation.
Over the years, there have been many academic discussions about advanced litigation theory. These often have involved applying outcomes and theories from other areas, such as mathematics, to the litigation process.
Over the years, there have been many academic discussions about advanced litigation theory, much of them involving modelling outcomes from other fields such as mathematics and how you can apply that to conflicts. And one of the most interesting mathematical studies is game theory. Game theory is all about how decisions of a participant are influenced by the actions of another. And you can use it really effectively to model settlement outcomes, looking at things like how the costs of a litigation will reduce the amount of the sunk cost that's available, how actually negotiations are really about the division and allocation of those costs, understanding that parties' behaviour has an impact on the ultimate settlement that may be achieved, and also how sometimes aggressive approaches aren't always the best and can lead to worse outcomes. Now, in basic terms, this can work in the following way. So you have to firstly understand what the value of the dispute is. So let's say, for hypothetical purposes, you have a claim of £1 million and you assess that that claim has a 50% prospect of succeeding. So if you're a claimant, you need to value that claim. So you value the claim at £500,000 because you've got a 50% chance of getting £1 million and a 50% chance of getting zero. So having done that, then you need to work out, well, look, actually, what's the value to me as a claimant if the case goes to trial? And let's take into account the costs of the trial as well. But the question is, how much would you be willing to settle prior to the hearing as a result of the trial? And perhaps counterintuitively, from a claimant perspective, the amount that you'd likely settle is $500,000 because the costs that have been incurred actually don't really make a difference in that analysis because they're sunk. But they do make a difference in terms of a net recovery. So obviously, if you incur costs, you potentially get less at the end of the process. So let's assume, hypothetically, you incur or will incur £300,000 of cost to trial. So that means you get to trial, and let's say you settle at the very end, you might recover £200,000, the £500,000 value less the cost. So if you were to receive an offer at the beginning of the case, before you've incurred meaningful costs, and let's just say that the defendant says, here's 200,000, the question is, should you accept that? And, bizarrely perhaps, the answer is it doesn't matter from a game theory perspective because you're either going to get £200,000 then or £200,000 at trial. Another academic approach that can be applied to modelling disputes is the Monte Carlo method or Monte Carlo scenario around expectation theory. Now, this is a really interesting approach where you take a number of data points and you model them and you use a computer, normally a piece of software that's relatively inexpensive, and it will plot on a probabilistic curve a range of potential outcomes. And you can use that at an early stage in your wargaming scenarios to understand possible strategies for settlement and get a lot of data at an early stage of the case, and it's a really useful additional weapon in your armoury.
One way of mitigating the risk from litigation is insurance. A variety of products are available.
The most common litigation risk product is adverse cost insurance, and this is by far and away the most common policy in the market. And in effect, the way these policies work is that the claimant will speak to their law firm at the outset of the case or later on, depending on it, and they will say, how much is the adverse cost liability that I will face in the event I go to trial and the case is lost? So the law firm will take a view and say, for the sake of discussion, that it's a £1 million liability. The law firm will come to us and ask us whether we're prepared to insure against the eventuality of the case being lost. On those cases, the case proceeds as per normal. There are some reporting requirements from the law firm to the insurer as the case progresses. But then at the end of the case, if in the hopefully unlikely event the case is lost, we would pick up the adverse costs so that the claimant doesn't face that liability themselves. Apart from that type of policy, there's some other policies which are becoming more common, which come into play once the litigation is a little more advanced. So, for example, if the claimant has obtained a first instance decision, they've been successful in the first instance and they're facing an appeal, it's possible to look at to underwrite the prospects of the appeal being successful and the first instance decision being overturned. So, for example, if a claimant had an award for £10 million from the first instance decision but was facing an appeal, there'd be the potential for the claimant to insure some of that £10 million so that even if the appeal is successful, they still have a positive financial outcome. The other area where there's been some developments is in respect of policies arising from acquisition type situations. So where, for example, company A wants to buy company B, but company B has a large liability on its balance sheet arising from a piece of litigation. It's possible to go in there to look at the liability and then to take a realistic view as to what that liability ought to be, and then to put some insurance in place so that that liability is effectively crystallised. The buyer of the company, of company B, knows exactly what they're going to pay because they have an insurance policy in place to cover against that, that outcome being exceeded. So if there is a product which has litigation risk at its heart, the market is becoming increasingly creative about putting policies in place to work in that context. Certainly where we take comfort is where the law firm instructed on the case has done some preliminary work, sought some preliminary expert evidence, even if it's only a limited scope to the expert evidence. They've done some work seeing what documentation is available, speaking to the key witnesses in the case, and just giving us a more fulsome picture of what the case is about and what the case is likely to turn on, and it certainly makes our underwriting decision much easier.
Reputational risks arise in pretty much all litigation, actually, because whilst there might be parties who particularly seek to push things into the public arena, irrespective of that, there will be touch points at which things will become public, generally in litigation. So through court hearings, through disclosure, there might be lots of different details which come into the public domain which you might not have originally anticipated at the start, and those can be of varying levels of interest to the public, to your customers, and to people that you transact with. So we would really encourage people to think about that as a risk alongside the inherent risks within the litigation itself, because those reputational risks can obviously have much wider ramifications, particularly for a company. We dealt with this in a lot more detail in our In Dispute series last year, which is still available, and I'd really encourage people to look back at that if they are contemplating litigation so that they can think about how these factors feed in.